the Eastern Caribbean Supreme Court. It stands as a pillar of integration and remains one of the most stable regional institutions, despite the challenges it has undergone in its 50-year history. The ECSC was set up by the West Indies Associated States Supreme Court Order No. 223 of 1967 and boasts of distinguished leadership, with judges who have set themselves apart, many of whom now hold recognized positions regionally and internationally. The court's 50-year legacy has been preserved by outstanding judges led by eminent Chief Justices Sir Maurice Davis, Sir Neville Peterkin, Sir Dennis Byron, Sir Hugh Rawlins, and the first woman and current Chief Justice, Dame Janice Pereira, DBE.
We were able to come together as a body, and we have been able to sustain ourselves as a body. We have not said, oh, I'm going that way or I'm going my own way. We realize the strength in unity, and we have achieved that. We have gotten to 50 years, and that in itself is a great, great accomplishment for any organization, especially where the organization depends on not just an individual, but many individuals, many territory, many minds and opinions and views coming together. And I think that is what we should use as an example when we go through life.
The Eastern Caribbean Supreme Court is the only court of its kind in the Commonwealth. It's the only court that serves 9 different jurisdictions. We have one Judicial and Legal Services Commission appointing judges throughout the 9 jurisdictions. We have one Chief Justice, who is Chief Justice for the 9 jurisdictions. We have one Court of Appeal serving the 9 jurisdictions. There is no other court. Trinidad has its own Judicial and Legal Services Commission and Chief Justice. Same for Jamaica. Same for Barbados. Same for Belize. All of these countries. But we have a court that serves all 9 jurisdictions. And what that is also good for, like the Eastern Caribbean Central Bank, is regional integration.
By and large, the decisions, the judgments of the court has stood the test of time. And many of the decisions have been upheld, particularly on the criminal side, by Her Majesty's Privy Council, our current final Court of Appeal. And decisions have been referred to and cited by other courts in the region and internationally. So I think we have come a long way for the past 50 years. But there is still a long road ahead in order for us to have an effective and efficient judicial system in Grenada.
The ECSC has made significant strides in criminal justice, mediation, public law, commercial law, and social law. And in 2000, it transformed its rules into modern civil procedure rules, second in the Caribbean to Trinidad and Tobago. And to better serve its 6 independent states and 3 British overseas territories, the court has put in place, at least partially, electronic distance litigation mechanisms. Acting as the heart of the court is the Registry, pertaining to matters of a civil, criminal, or matrimonial nature. The Registry uses a system called the Judicial Enforcement Management System, or JEMS, GEMS. This is an IT platform that allows the court to ensure that all information concerning cases are managed. Acting Registrar Mrs. ALANA TWUM-BARIMAH says they are anticipating a more updated system of judicial management soon, with IT being critical for the efficient functioning of the Registry.
One of the things that I think needs to definitely happen for our court is to implement that new system that we are anticipating will be coming from headquarters, the Eastern Caribbean Supreme Court, because I believe that it would change everything. If we have an e-filing system, a system where persons can stay from their office and file, a system where litigants can log on if they need to and see how their matter is progressing. Attorneys can do the same. The registrar, judges can see exactly how the court process is happening.
I am grateful for technology, though. it has enhanced at least my life sitting on the bench. If you see the amount of notebooks I have since I started to sit, because you have to be writing, you had to be writing everything. Now everything is recorded. You don't have to say, okay, stop a minute, I need to take a note, I didn't hear what you say, if you do not want to, because we have simultaneous recording. Also, the judges, they all have computers. And whether or not you use that computer, how you decide to use it. For me, I type my notes. So it makes my life easier in many ways, many respects, because now I can get off the bench today, and if I choose to, I can prepare my summing up for tomorrow.
And there are other innovations that it can boast of. One such was the principle of the master. The first master was Justice Hugh Rawlins, who went on to become the Chief Justice of the court.
The system of the master works because it could help to expedite matters. It take some of the matters out of the hands of judges, and it could be dealt with at the level of the master, who is a judge, but a judge confined to sitting in chambers. And then in 2000, we introduced these new civil procedure rules. We had previously been operating under rules from 1970. So we introduced the new civil procedure rules.
One of the greatest benefits of the introduction of the new rules is that parties are no longer caught by surprise in the courtroom as to what is the nature of the case they're coming to meet. The rules require disclosure up front. The rules require parties to state the case clearly, succinctly, and to certify that what they are stating, both in the pleadings and in the witness statements, are true. By virtue of the stipulation of the rules, you are not permitted to change your case on the other side. So parties know there's a certain degree of certainty that the rules have introduced into litigation, so that parties are not caught by surprise. And I think that's a good thing.
We had introduced into the legal system in Grenada, under this court, the system of mediation. I am a firm advocate of the system of mediation. I believe it is one of the best innovations in our jurisprudence, because it enables litigants, with the aid of trained mediators, to be able to effect compromise settlements of the matters.
The court has received valuable assistance from Canada to significantly reduce the backlog of pending cases in Grenada. This in turn can help to speed up preparation of transcripts of court proceedings to process civil and criminal appeals.
We now have persons in custody awaiting their appeal in excess of 5 years, and instances where such persons have also served their time, they're out, and the appeal has not been heard.
It is not acceptable that persons might complete serving their sentences before their appeals are heard, only because transcripts are not ready. This is wrong. Indeed, the Court of Appeal has held that inordinate delay by the prosecution in preparing the record of appeal in an appeal against conviction, while the appellant has already served the sentence, violates the right to a hearing within a reasonable time. But the court did not, on that ground alone, quash the conviction. It might come to that one of these days. So too, judgment should be far more speedily delivered than at times happens now. Delays in giving judgments are sometimes too long. Justice delayed is justice denied.
But the reality is, these are some of the myriad of challenges the court experiences. time constraints, and issues relating to bail are some of the major hurdles experienced.
Somehow, we have to rise to the level of providing judges with the support staff required to advance the work. Once the litigation work, the trial is over, there should be trained staff, 1 or 2 persons assigned to a judge to do a certain amount of preparatory work towards the delivery of the judgment. I think once we can rise to that level, we'll be doing pretty well in this jurisdiction.
We still operate on a common law basis, given unlimited discretion to the magistrate. That ought to be curtailed, and there must be prescribed conditions upon which bail ought to be given. I would prefer to see us return to the situation where bail is granted as a matter of right for trifling or summary offenses.
We need to be able to teach and help our people learn and understand the law to the best of their ability so they can also represent themselves. A lot of times, a lot of people cannot afford legal services. A lot of times, lawyers cannot afford to give time to do as much pro bono that they would like to, as there are other demanding issues that they have to attend to for themselves. That said, that leaves a window open for us to be able to express and teach our people to be able to represent themselves.
Going forward, we need to have certain things in place. The heavy workload of the court really is a confluence of several factors. A critical component is the private bar. The private bar in Grenada is very small. In fact, too small to handle the number of cases or the number of accused persons who come before the court. A corollary of that is the fact that many accused persons are not able to retain counsel. So that going forward, it is important, if the workload the court is carrying, particularly in the criminal jurisdiction, is to be reduced or brought down to manageable levels. We need to see greater interest in the criminal bar. We need to see a more effective and a broader legal aid scheme. The fact that the court infrastructure, both the physical and the personnel, is not at the level to achieve efficiency.
We currently function out of one office, which is on Church Street, and the court itself, 4 courts, are at a different location. We are the administrative helm, the Supreme Court Registry, and the court is basically the actual machine, just getting things done. But it really is difficult when the two can't connect. Apart from that, we need to see development in the court reporting unit. Ability to produce transcripts in a timely fashion is extremely important. The ability to access the vault area of the Supreme Court Registry without any headaches is critically important. We are the repository for documents. And if, as a repository for documents, we do not have a proper space, not just a proper space, but a proper system and management system to ensure that these documents are safe, then we basically are not accomplishing what our critical and most key role is.
But wisdom, uplifting justice, and standing for principle have enabled the court to emerge unscathed from some of the challenges it has faced, like the 1967 Petition State of Emergency, the 1980 attempted overthrow of the government in Dominica, which resulted in a former prime minister being imprisoned.
The most traumatic was the court having to watch Grenada go in the revolution in 1979 and come in 1991 after the revolution ended in 1983.
Another notable feature is the court's collaboration with the OECS Bar Association to improve the administration of justice. a partnership that has been ongoing since 1989.
Every year for the last 13 years, both the court and the bar have collaborated as far as the joint symposia over those years. Then we have established bar bench committees, and that has been promoted by the OECS Bar Association over the last several years to have every country, every entity among the 9 states that fall under the jurisdiction of the Eastern Caribbean Supreme Court and of course the OECS Bar Association to establish bar bench committees. And the focus of those bar bench committees is really to ensure that we take a collective approach to solving problems.
Former Bar Association President Ruggles Ferguson is convinced that this collaboration spells a bright future for the court.
With the program of the bar, the OECS bar and the constituent bars, and the program of the Judicial Education Institute of the court, that this court and this region has a bright future as far as the administration of justice goes.
A bright future indeed. Meet Delon Charles, a young attorney employed at the law firm Wilkinson, Wilkinson and Wilkinson. He has immense faith in the legal justice system, which he says is teaching him some valuable lessons.
Understanding and that you need to be prepared at all times. No case is ever guaranteed victory. There might be some loophole, some technicality where your case can be blown apart and you end up on the losing end rather than the winning end. And there are also different ways of winning. You may win the case, but you may not win the case on quantum, which is to most people the most important part. Lawyers are able to minimize the amount of damages some people are awarded based on case law. My experience has shown me that based on precedents, and if you're prepared enough, you can minimize a $100,000 claim to merely $10,000 or $5,000 within an hour of presentation to a judge. And once persuaded, that is the award given to the aggrieved party.
This bright future involves assisting young offenders, and so there is greater focus on juvenile justice, with Grenada having implemented the Juvenile Justice Act and now has the Grand Bacolet Juvenile Center in operation.
I'm happy that Grenada has gone ahead, and not only gone ahead of many of the other territories. I think Grenada is one of 4 territories that have already implemented that act, and I appreciate that. It makes my life as a judge much easier, because now I know what steps to take in relation to a child who comes in conflict with the law.
The role that women play in the court today is greater than that played many years ago. There are now more female judges and a female Chief Justice. It brings a balance, especially when dealing with young people.
Throughout the years of the court, we know that we have not had many female judges. And not only do we have female judges, but our Chief Justice, and I applaud her. She is a guiding light. She's a shining example, not only to us judges, but I'm sure to every young girl who comes along or coming along in life and realize, you know what, I can do that. I can be at the top of my game. I can rise above all my situations, and I can get to that position. It may not necessarily be Chief Justice, but in any other area. And that is one of our greatest experience, and my greatest experience sitting here as a judge. And even in Grenada, we have had at one point in time 3 female judges. Then we had 2 female judges and 1 male judge, and now we're equally balanced, and I'm sure the men are a little happier for that.
When I was a student of law, the men outnumbered women. Not so now. The women outnumber men by about 2 to 1, with the graduating classes, almost. I've seen a woman take the leading role in advocacy. Well, look at me as the first Grenadian QC, female QC. I recall I was present in the Court of Appeal the first time an all-woman panel sat as the Court of Appeal. I was present, and it was an honor for me to do so.
Looking forward to the next 50 years, the court needs to place greater emphasis on lessening the number of unrepresented persons and increasing the pace at which it disposes of criminal matters. But in the face of all of this, the court has been able to distinguish itself from its work, showing that the Caribbean can run a regional court of the highest quality.
The Eastern Caribbean Supreme Court has in the last 50 years been a model regional court. Let the next 50 years see God blessing the court and all, whether in the Eastern Caribbean or beyond, who expect justice from the court. The justice, the righteousness so often exalted in the Bible.
Go to production. Capture the moment.